Thank you very much, Mr. Chairman, and thank you very much to the Bevel Cadbury Trust and the organizers for inviting me and to speak here in this wonderful room and in front of so many motivated people. I already now apologize for the English mistakes I will make and for my strong German accent, but I hope that I will have convinced you at the end of my presentation that it was nevertheless a good idea to invite me to your meeting. I would like to present some foreign experiences with young adults in criminal justice systems. As you probably know, in Germany, young adult offenders are integrated into the juvenile justice system to a certain extent, and I wrote my doctoral thesis about that and later on worked in a big research project about juvenile justice where we looked at 35 juvenile justice systems in Europe and further investigated the question of the treatment of young adult offenders. So this is what I want to present here today. I would like to present first additional arguments for integrating young adults into juvenile justice or for a special approach to young adult offenders. The speakers before me highlighted interesting results, and I do totally agree with them, but there is a further argument that could be of interest here. After this, I would like to present a short overview about the integration or non-integration of young adult offenders into juvenile justice systems in Europe. And I will then present the German system of dealing with young adult offenders, and then I will hopefully on time close my presentation with some conclusions. Let me start with some introductory remarks. We have already heard many reasons this morning why it seems reasonable to follow a distinct approach to young adult offenders in the criminal justice system. One argument has not been considered so far. To a certain extent, international law binds England as well as Germany or Poland, Spain or Russia to integrate young adult offenders into juvenile justice. Two recommendations of the Council of Europe do clarify this. You find the one section of the one recommendation which stems from the year 2003 here, and the other one stems from the year 2008. And both recommendations explicitly postulate the integration of young adult offenders into the juvenile justice systems based on the experiences and the sociological and criminological findings which have already been presented here this morning and which are the same all over Europe. One may argue that such recommendations, if not formally transferred to national law, are only so-called soft law and not binding for national legislators. However, this is only partly true. We should not forget that no lesser personalities than the ministers of foreign affairs of all 48 member states of the Council of Europe express their common political will through such recommendations. Should this not produce some political or at least moral pressure on our governments? Furthermore, the German and the Swiss highest courts, and probably more highest courts in all over Europe, expressed that recommendations adopted by the United Nations or the Council of Europe do influence the interpretation of national legislation. Kevin and Susan and the speakers before me in general have already highlighted psychological and sociological aspects which show the extended transition to adulthood. I could present similar data from Germany or other European countries because these developments are comparable in all of Europe, oftentimes influenced by the pan-European problem of youth unemployment, as we have heard before. And we have already been informed by Susan this morning about criminological aspects. Please let me support her conclusions by presenting the German age crime curve, which shows the growing out of crime and shows that the peak of prevalence rates lies in Germany between 18 and 25, and therefore in the age group we are talking about today. I have already told you at the beginning of my presentation that we analyzed, with the help of juvenile justice experts from all over Europe, how young adults are treated under criminal justice legislation. For example, from England, we were supported by Professor James Dicknin, from Scotland by our friend Michelle Berman. We identified 3 models of legislation in all over Europe. We can find countries with special regulations within the juvenile laws, which make the educational juvenile justice measures applicable for young adults as well. We can furthermore find countries with special regulations in the general criminal law mitigating the sentences imposed on young adults. For example, in the Scandinavian countries, which do in general not have specific juvenile justice systems as such, but a lot of regulations that allow for specific approaches for juveniles and young adults. And we do find, last and least, countries with no special rules for young adults at all. You can see that we put England and Wales here into this category. I am aware about the existence of young offender institutions, but this was not what we were looking for, because we looked at material law and not at regulation concerning the prison regime. We will come back to that later. In public debates, the integration of young adults into the juvenile justice is often seen as a weak or a mild or a less consequent approach. I think for all of us here, it is not astonishing that this conclusion is wrong. But what is the true effect or the advantage of integrating young adults into the juvenile justice system? This depends on the criminal justice system in the country, of course, and the particularities of the juvenile justice system in the same country. Anna has already spoken about this morning. In most countries, the adult criminal justice system provides fines and prison sentences, which can be suspended under special circumstances. Some other countries, but not all, know the sanction of probation, as it is understood in the UK. Only a few countries provide alternative sanctions like mediation or special training courses or other similar forms of social assistance within their adult criminal systems. But most do in juvenile justice systems. Juvenile justice systems do oftentimes provide a huge variety of responses to criminal behavior. Diversion plays an important role in juvenile justice, and so do alternative sanctions, which often follow special educational approaches. The offender's personality usually plays an important role in juvenile justice, and the sanctions and measures aim not only to punish him or her, but also to reintegrate the offender into society. This aim is much more emphasized than it is in the juvenile justice systems than it is in the adult criminal systems in most countries in Europe. Here on this slide, you see which countries do belong to the group which provides special regulations for young adults in the general criminal law concerning mitigating sentences. Within the green circle, you find countries with special rules for young adults which provide the application of juvenile law sanctions. In the middle, you find a lot of countries where both alternatives are given, And in the yellow circle, you find countries where no such regulations are provided. And you see that you are on a level together with Bulgaria, Estonia, Latvia, Spain recently, and Turkey. The following tables try to differentiate a little bit more. They contain a lot of information, but please, I would like that you take your attention to the columns 4 and 5. In the fourth column, you find the age up to which juvenile law or juvenile sanctions can be applied. And in the fifth column, you see the age range for youth imprisonment or similar forms of deprivation of liberty. Here it is where young offenders institutions or similar institutions are considered. The Netherlands created a similar regime for young adults in 2002, and Turkey likewise provides for special institutions for young adults. You can see, if you look at the last column, the interesting result that young adults are, in all countries, accepted as a special group if it comes to deprivation of liberty, and are, with good reason, separated from adults. There are countries where young adults do stay even longer, until 25 in Sweden or even 30 in Switzerland, in special institutions for young adults or juveniles. Let us use the last part of my presentation for talking about German experiences. In Germany, since the reform law of 1953, all young adults are transferred to the jurisdiction of juvenile courts. Comparing practices internationally, this decision is remarkable because it points the way to extending the scope of special juvenile courts for young adults between the ages of 18 and 21, already at a very early historical stage of European development. So, if someone commits an offense between the ages and 20 and 21, the youth court is competent to decide. Whereas the criminal sanctions of the general criminal law provide fines, suspended or unconditional prison sentences, the Juvenile Justice Act enables the juvenile judge to choose educational measures such as community service orders or other restorative measures or social training interventions in order to improve social skills and so on. These sanctions can be tailored according to the educational needs of each individual offender, and as a last resort, the imposition of a youth prison sentence is possible, which in general will be shorter than a prison sentence for adults. In case of young adults, Section 105 of the Juvenile Justice Act provides the application of juvenile sanctions under special conditions. We will later see that in the majority of cases, young adults are in fact sentenced according to juvenile criminal law. Here you see under which circumstances the judge can apply juvenile sanctions. According to the first alternative of this section, the judge can apply juvenile law if a global examination of the offender's personality and of his social environment indicates that at the time of committing the crime, the young adult in his moral and psychological development was like a juvenile. This is maturation. To define this criterion, the Supreme Federal Court held that a young adult has the maturity of a juvenile if elements demonstrate that a considerable development of the personality is still to be seen. According to another alternative of Section 105, juvenile law has to be applied if it appears that the motives and the circumstances of the offense are those of a typical juvenile crime. Here you can find what our courts see as typical juvenile behavior. We do not have to go into that now more deeply. I think it is important for you to understand that the regulations allow for a lot of discretion. And so it is important to see how the judges do use their powers in practice when dealing with young adult offenders. As you can see here, the practice of German juvenile courts is convinced of applying juvenile justice to young adults. In 1965, only 38% of young adults were sentenced in terms of the Juvenile Justice Act, but by 1990, this had nearly doubled to 64, and then after that increased to even 66 in 2009. This clearly indicates that the full integration of young adults into the juvenile justice system has been accepted in practice. The regulations mentioned before have also been widely interpreted by the courts to provide for the application of juvenile law in all cases where there are doubts about the maturity of a young adult offender. This victory of the application of juvenile law when dealing with young adult offenders may be attributable to its increased flexibility in comparison to the limited sanctioning options of the general criminal law. But not everything is as golden as it seems for young adult offenders in Germany. The different German federal states apply Section 105 slightly differently, as you can see here. There are federal states like Mecklenburg, West Pomerania or Baden-Württemberg which apply juvenile criminal law in only 50% of all cases involving young adult offenders. And there are other federal states like Schleswig-Holstein or Hamburg which do apply juvenile law in almost all cases of young adult offending. The reasons for these differences cannot be found in different maturity levels, but in different political opinions and, as a consequence of this, different use of discretion. But there are also other reasons for the difference in the application of Section 105. Here you can see that after severe offenses, the application of juvenile justice sanctions is much more likely than after lesser offenses. The reason is that the judges want to eschew the application of the general criminal law in order to avoid the imposition of more severe punishment. What is astonishing is that after traffic offenses, only 17% of our young adult offenders are sanctioned according to juvenile criminal law. The reason is that juvenile criminal law does not allow the imposition of fines in a summary procedure without an oral hearing. But this procedure is very economical and time-saving and is used particularly for traffic offenses. As I indicated before, there are other regulations concerning young adult offenders within our laws. If the court does not apply juvenile sanctions, the sentence of the adult criminal law shall be mitigated, and it is mitigated in the majority of the cases in practice. So let me use my last minutes for a short conclusion. Europe-wide, we do have scientific findings regarding the living situation of young people which show that young adults are in many aspects comparable to juveniles today. As a consequence, it would be reasonable to have supportive and flexible possibilities for sanctioning young adult offenders, and this is also in line with the requirements of the recommendations of the Council of Europe. The review of 35 legal systems shows that the idea is already widely shared across Europe. Despite some problems, Germany has found a way of integrating the majority of young adult offenders into the juvenile justice system. If you are interested in reading more about this, I would like to recommend to you these books. I only brought one copy of it, but you will find, you do find articles about the treatment of young adult offenders in Europe and in Germany. So if you want to read more, please feel free to ask me afterwards or to write me an email, and then I can answer your questions. And yeah, I would like it very much to help you to fight for the young adults in your country, and I wish you the best for this fight. Thank you for your attention.